Okay, so I got a handful of interesting horror stories to discuss today. So easy missteps that can cost you big money. We haven't done this in a little while, and Kimberly's back from all of her excitement, so this is just what she needed to bring her back into reality.
Yes, horror stories.
So here's a quick overview of what I've prepared for us to chat about today. Cooperation and compensation review, DocuSign follies, how writing up the deal on the wrong form can get you sued, fraudulent buyer case study, and relocation/institutional seller proprietary contract issues. And I know that last one just has everyone on the edges of their seats. All of these issues came up in a period of about 2 or 3 weeks, all within our firm. And I will start out by saying the examples that I'm going to give, and I'm not going to identify any of the agents, the examples I'm going to give did not involve any of our agents doing anything fundamentally wrong. Nobody made any stupid mistakes. There were mistakes, but none of them were kind of, you idiot, how could you possibly do that? They were all kind of shockingly easy missteps that could easily land you in a spot where the stakes are very high, and that's part of why we're talking about it. Our agents are good enough that we don't have people frequently making stupid mistakes here. It's the stuff that you could slide into unwittingly that's the bigger problem, especially if it is a high-stakes deal. NAR Code of Ethics, Article 3. So this is, as you're all aware, the NAR Code of Ethics has the articles, and the articles are what are binding. The standards of practice that follow each article are sort of like example case studies. It's the article, though, that you would essentially be charged with violating if there were to be an alleged violation. So realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. So that means the default setting is we must cooperate. The obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. People often forget that that is the case. I had an issue with one of our agents several weeks ago where it was a property that was just a little out of our geography listed by an agent from an adjacent MLS. It was not in our MLS. Our agent showed it, did not solidify that other agent's willingness to compensate, and you end up just sort of out of luck. So the key to this is you never, ever, ever want to show a non-MLS listed property without first securing in writing that you're going to get paid, not just cooperated with. Because if that other agent, or if it's a for sale by owner, if they're not willing to cooperate and to pay you, then you either are going to get completely left out in the cold, or you have to then approach your buyer and say, if I'm going to represent you on this property, here's how this is going to work, and you're going to pay me. And of course, in many cases, the whole reason the industry is set up so the seller is paying both agents is because most buyers are not in a position to write the check for their down payment and then write you a big check. So something to be aware of. This is Standard of Practice 3-1. Realtors acting as exclusive agents or brokers of sellers/landlords establish the terms and conditions of offers to cooperate. Unless expressly indicated in offers to cooperate, cooperating brokers may not assume that the offer of cooperation includes an offer of compensation. Terms of compensation, if any, shall be ascertained by cooperating brokers before beginning efforts to accept the offer of cooperation. So, if you start doing a showing because you've called some agent in an adjacent MLS that has a property listed, especially in some outlying small town, that's the most common example we deal with, and they say, sure, here's the combo box code, you're welcome to get in, have at it, but you don't specifically talk cooperating compensation. Again, that's what this standard of practice addresses. Realtors, this is 1616, Standard of Practice 1616. Realtors acting as subagents or buyer/tenant representatives or brokers shall not use the terms of an offer to purchase to attempt to modify the listing broker's offer of compensation to buyer representatives or brokers, nor make submission of an executed offer to purchase contingent on the listing broker's agreement to modify the offer of compensation. So this reads more complicated than it needs to be because it's got multiple terms, but the bottom line is we are in violation of the Code of Ethics if we attempt on an offer to modify the offer of compensation. There's two issues with that. Number one is it's kind of tacky because you're putting your paycheck issues on the document that's the contract between the buyer and the seller. So there's a protocol tackiness issue that I think is perfectly legitimate, but it's ethically prohibited. If you have a compensation issue, it's absolutely imperative that it be worked out between you and the agent with whom you seek to cooperate prior to the execution of the contract and in writing. And that can be done in a number of ways. Our agents all have autonomy to be able to do whatever they want, so if you're willing to make a commission concession, you don't have to typically come see Bill or see me about it. We certainly welcome consultations on stuff like that, mostly because we want to make sure you're not making commission concessions if they can be avoided. However, you want to make sure, since you're all empowered to do a commission concession if you wish, that could be anything from, if you trust the other agent, an informal email exchange where you at least have in writing in your email records, yes, I agree that I'll happily pay you X, and as long as you're okay with X, knock yourself out. In an absolutely perfect world, since the offer to compensate is broker to broker, not agent to agent, in an absolutely perfect world, which would also mean if you have any fundamental discomfort or distrust of the other person you're dealing with, get it in writing in a more formal letter from that firm's managing broker. Any questions about that?
Commissions are due at closing, aren't they, unless you agree otherwise?
It depends on how you define it. So if you're doing an unconventional sale, if it's an installment sale, or if it's a contract for deed of some sort, you could potentially define that closing date any number of ways. So look to the listing agreement verbiage, but anytime you're in a situation that is the slightest bit, obviously the listing agreement could be perfectly detailed and flawless, but if the clients aren't paying attention to it and they're not expecting to have to pay you when you're expecting to get paid, there's a problem. So no matter how detailed the listing agreement is, make sure you underscore to the seller, if you want to do this, please understand that for the purposes of our listing agreement, I'm expecting that you're going to pay the brokerage fee that's due in full on the day when we sign these documents, or on the day when the first installment is due. You don't get to pay in long-term installments unless you've specifically agreed to it. The other practical issue is by saying to the seller, no matter how, because what happens is these sellers will tend to think, oh yeah, this contract sale is all good. And we know in reality that the reason people do the contract sales in most cases is because they have a financial issue that makes them incapable of getting conventional financing. And so if that's the case, putting that obstacle at the very front of that process means the buyer's going to have to come up with a bunch more money because the seller won't accept the offer unless there's enough cash up front to pay the brokerage fee. But having enough cash tendered up front to pay the brokerage fee in and of itself is a big enough hoop to make the buyer jump through, that they're much more likely to perform because they're going to walk away from a bunch of sunk costs.
Yeah,
so,
and it was the seller's idea, which was great.
Perfect. So bottom line is you cannot have on any offer to purchase or in your contract anything having to do with the compensation. If your offer is premised on, and so the most common flavor of this that I have come across in my career is you get buyer and seller to within that last $1,000 and they've both drawn lines in the sand. There's no way they're willing to be in a standoff and walk away from each other. Devon and I know how that feels. And you may find that, fine, but I'd rather suck it up and take the $1,000 hit myself than lose the sale and have to start over from scratch. So if you make a business decision, we don't take lightly commission concessions. But if you make a business decision that is the sensible thing for you to do under those circumstances, that's totally fine. But the way you want to handle that is you tell your seller, or whoever your client is, you say, here's the deal. You're going to sign this contract that is for that $1,000 high or $1,000 less than you are willing to take, Mr. Seller, or for $1,000 more than you were willing to pay, Mrs. Buyer, if you were on the buyer's side. But here's separately, here is the agent and the client, here's our written correspondence confirming that I'm promising to the buyer that I'm rebating $1,000 back to you after closing, which is legal if it's a party to the contract, they don't have to be licensed. So you could either say if you were coughing up a concession for this buyer, either rebate it back, or better yet, tell the listing agent, cut my cooperating compensation by that amount, and then the buyer will end up getting the better price. The seller takes $1,000 less, but is assured separately in a separate correspondence that their brokerage fee is being reduced by that same amount. Does that make sense? And it is legal to do a commission rebate to the buyer, but in most cases, as between a commission rebate versus getting the buyer the better price, unless they have to have that cash in their hand right after closing, you don't want to do the commission rebate because it triggers a 1099 requirement. They're going to have a taxable event, whereas if they get the house for a better price, there isn't a taxable event. Susan?
Wouldn't that also need to be reported to the bank, I guess, as a concession that they're getting money back, or is that something the bank?
No, not necessarily.
Okay.
No, it's legal because that's a really good question. So I had to think about it for a second when you asked it. But because they are a party to the contract, it is legal for us to pay them, and it's not being done as part of the closing. That is a legitimate paid outside of closing. And it really is no different.
Is it on the HUD?
No, not the rebate back to them. It is not. because the commission that's being paid is there, and then you're separately agreeing to do something that involves a rebate. It is no different than a whole bunch of the big online operations, lending tree type operations that try to pull buyers in by saying, if you work with one of our certified agents, which just means somebody who's agreed to pay a big referral fee, then we'll give you, a $200 Lowe's gift card upon your closing. Well, from our standpoint, what it means is we end up with a 30% referral worth $1,000 or $2,000 so that the client can get a $200 gift card. So there's no prohibition against short-circuiting that and saying for whatever reason, I'll do the, and in fact I have done this. I bought a client out of one of those deals. I said, let me spell all of this out for you. Here's exactly what your lender through their agent network is offering you. Here's what it's costing me. Let me offer you a cash bonus that is more than what you would have gotten, while it is still less from me than I would have paid if you stayed in that network. You have total autonomy to do that. But again, the whole point of this conversation is anything involving the compensation has to not appear on the offer or on the contract. You always have to think of it as a separate deal, and just like the contract is between buyer and seller, your commission situation, if you're on the buyer's agent, is between you and the listing brokerage. And if you're the listing agent and you're doing anything with commission concessions, it is a separate chain between you and your seller. Susan?
I understand that perfectly when you're working with another brokerage. But let's say, sometimes in the area where I work a lot in, it's a lot of for sale by owners. And I use our standard MLS contract, for better or for worse, whether we're allowed to or not. And I usually write, the seller will pay the next realty 3% at the bottom of the listing at closing, commission.
The bottom of the listing?
The bottom of the offer, offer. Because they're for sale by owner.
Yeah, can't do it.
Can't do that?
Cannot do it. The way you have to do that on a for sale by owner is we have an obligation at first contact to let a for sale by owner seller know. And Susan encounters this more than most of us because of her geographic area and the interesting variety of sellers that are there. But we all encounter it from time to time. So we have a couple of ethical obligation issues there. Number one, we have an obligation to inform any seller. If you're expecting them to pay you, which is normally the expectation, we have an ethical obligation to make sure they are aware that that is your expectation upon first contact. You don't have to have a contract signed to that effect, but you have to make them aware of that.
I would just say absolutely yes, they're made aware of that before the house
Oh,
is
sure.
ever shown.
Yeah, and I was not assuming otherwise.
Sometimes it's awkward getting something in writing until they see an offer in front of them.
That's fine. When it comes time to do that, you need to have a separate compensation and agency disclosure. And I have a form that you are all welcome to use if you, and I've had many of you approach me over the years asking what do I use, and I've provided it when it comes up. But we have two issues there. We have an agency disclosure. Hey, Mr. and Mrs. Seller, this formally notifies you as required under the license law that I represent this buyer client. I do not represent you. So while you and I will deal with one another and I'll work you through the process and walk you through the steps, I'm their agent, not your agent. And in addition, I'm also expecting you, the seller, the person whom I'm not representing, to pay me. So we have a form that does both of those things. It is, in consideration of my bringing a ready, willing, and able buyer, you agree to pay me X number, or RE/MAX Realty Associates, X dollars or X percent upon the successful closing, and you're also hereby notified I represent the buyers. So it takes care of both of those things. You need to have that executed as a precondition of the offer, though, because we have on the one hand the ethical obligation not to include the compensation situation on the offer, but at the same time, if you just slide those two documents over to the seller, legally you run the risk that the seller says, yes, I will accept that offer, and no, I will not sign this other document. Then you're out in the cold. So I totally get the timing issue. And when you get to that point and you could then say to the seller, hey, my buyer wants to make an offer. Be transparent with your buyer so your buyer knows what's going on, so you're not hiding the ball from the buyer. Buyer wants to make an offer. Buyer is not prepared to pay me, so the buyer's offer is going to contemplate you paying me. I'm going to send you a document that's a disclosure of what I've already told you, because at first contact you want to let them know, hey, I represent a buyer client. If we do get a deal together, I would expect you to pay me X. So I'm going to send you, Mr. Seller, a document that puts into writing what we've already discussed. As soon as I can get that back, because parts of this are necessary under my license law, as soon as I get that back, we'll send you the purchase offer. And if the language, as is the case in the form I use, the language is only if it closes. It's not nearly as messy as the listing agreement, which could leave a seller thinking, I wonder if I could owe you a commission even if it doesn't close. So all good questions. We got into stickier issues than I was expecting. All good questions. DocuSign follies. So this will be a review for some of you. I guess maybe my battery's finally dead. That's why this doesn't work. I'll stop holding the placebo remote. Digital signature does not just mean that you're able to see that there's the client's name or the client's initials all over the document. That is a confirmation. I mean, it's one of those things that makes a DocuSign document look the way we expect a fully executed contract document to look, because you see the signatures there. But that really is not the key to DocuSign's usefulness. The key is that Adobe Acrobat files, or any type of file that you put into DocuSign, whether it's starts out as a Word file or anything else, anything that goes through the DocuSign process is spit out at the end as a PDF file that has a digitally authenticated signature on it. And when you think of that at the outset, so the whole file, think of it as one big package of documents, and that has a seal on it. And if you do anything that disturbs that package of documents exactly as it was spat out at the end of the DocuSign process, you are breaking that security seal. And I'll show you how that looks. I went and grabbed a recently closed file of my own to show you how you know, and how, if somebody ever needed to see, is this a digitally authenticated signature, or has this document potentially been altered but just bears the images of signatures on the signature lines? This is how you know. Up where you see the red circle, this has been signed and all signatures are valid. This document has not been modified in any way since it was spat out of DocuSign. If you have the full version of Acrobat, there's a couple ways you can work around that. If you don't have any special software, you print something out, add more pages to it, like the pre-approval letter and the copy of the Earnest check, and then throw it back through the scanner. But then you end up with a PDF that was scanned, so you're going to unnecessarily degrade the quality of the image because it's being printed and scanned an additional time, and you're going to end up with a new file that does not have digitally authenticated signatures. Now, if you scan something that a client sent to you or a client sent back, I mean, all of this really boils down to, if you end up on a witness stand because someone is calling into question the validity of your contract, how will you prove that it was valid, that it wasn't changed after the fact? So anything you do that breaks that seal means that somebody could argue that you don't have a valid contract. Doesn't mean that they would win, but it makes it much, much more complicated. And it means that instead of just sending over an Acrobat file that says right there on its face, essentially, I have not been molested since I was signed, which is a good thing. We like unmolested documents. Instead, you'd have to put together a timeline and say, here's the scan that I got from so-and-so at such a time, here's the one I got back later, or here's the one that was missing the earnest money check and the disclosures, but which was digitally authenticated, and then here are these other documents. So you can put together all the puzzle pieces and still make a case that it is a valid contract, but this really eliminates all of that by having its own internal verification that just says to all the world, if it's called into question, no. What you see in this file, every page, every word, every pixel is exactly as it was when it went in front of the parties. So the most common issues that I talked about would be adding disclosures or pre-approval to the contract after the execution, or changing the order of the pages. So the solutions, the takeaways here, always send the entire document with the disclosures, earnest money, pre-approval, etc. that you want in the final file. We have over the years gotten in the habit of, I'm just going to send you, Mr. Buyer, this one page. Page 1 is the only one where the price changed, and so I just need initials on page 1, send it back to me. Don't do that. Nowadays, with DocuSign, there's no reason to not send the whole thing. The reason would have been, I don't want to send my client 20 pages when one page needs an initial and have the client print 20 pages and scan 20 pages. With DocuSign, they don't have to print it, you don't have to scan it, they don't have to scan it. There's no paper waste. In other words, there is absolutely no reason not to send the whole thing. So when the offer comes in or when you're getting final signatures, go ahead and make sure that before it gets run through the DocuSign process, that you do any assembling, mixing, and matching of pages so that the whole contract, the exact complete package you would want to send to their attorney, to their lender, to everyone else, with the earnest money check, with the pre-approval letter if you already have one, with all of the disclosures. That is all in that package when it enters DocuSign. Also consider, this last point, consider asking the other agent. I have my team doing this frequently. Hey, do you mind, I say to the colleague, giving me your client's email addresses just for the purposes of DocuSign so that you and I, who both have separate DocuSign accounts, don't have to run it through two independent processes. Because there, again, one envelope in the DocuSign system shows that it went all the way through, instead of Devon having to pull up an envelope that shows, well, here's what I got from Matt that purported to be digitally authenticated, but it separately then went through a whole other process and got another envelope ID, and the authentication on the one that came out of her end of the process only authenticated her client's signatures, not mine. There again, we're in a puzzle. We have multiple puzzle pieces to prove that it's a valid contract. So, and the other kind of cool thing that I found when you're dealing with an agent that's not a DocuSign user is if they're at another firm and you offer to do that and you're very clear that you're not trying to pilfer their client and you're not going to become pen pals with their client, hey, if you don't mind, I'll keep you in the loop on this and you'll instantly be notified when they sign it. But if you don't mind giving me your client's email addresses and their full names, it also makes us look like we know what we're doing. It's a real convenience to the other agent, and it really makes us look like we have our act together. So I have seen nothing but upsides to doing that. It feels odd to say, would you mind giving me your client's email address? But as long as you're clear, I'm only doing this so that I can initiate the DocuSign process that will go all the way through. You will get CC'd on the final document as soon as it's signed. There's no reason for them to say no. It makes us look like we have our act together. You don't become pen pals with their client. And at the end of the process, one DocuSign envelope has the track record of every signature, every initial we needed. Any questions? Yep.
Yeah. When will you give that little seminar to the entire MLS?
This has got to be the 10th time I've said it to different groups at our office, because it is one of the most, yeah, I know, it's a preaching to the choir issue.
I have that issue with other agents. I had it all summer long. I send out the entire file.
And you get one page back.
And get back one page that had their signature.
So I encourage you all to preach that message to colleagues politely and respectfully whenever you have the chance. And you can be as non-menacing as, I don't want to make a big deal out of this. I don't want to make you redo all of your work, so we can make this work if we have to. But just FYI, in the future, we really need to keep all those pages together, because if we don't, it's harder for me to prove later if somebody calls the contract validity into question. It's harder for me to prove later because I now have bits and pieces here and there. And if it's somebody, people are not, well, I've had a few people do it with DocuSign where they'll just send the one page, but more commonly it's just that you get a scan of one page. And there is no, it becomes almost impossible to prove absolutely in an airtight way that that one page wasn't, yes, there's no argument that we all have initials on that one page, but we only agreed to that change in terms on that page because a different page got changed and you don't have it all together. So that, those are examples of how that can get very slippery. And so as soon as somebody's not happy with how things are going, they're going to claim that it's not a valid contract. Or a client that was previously not lawyered up gets lawyered up, and the first thing the lawyer decides to do is, all right, well, let's assert that there's no contract here. Okay, why the wrong form may mean the deal is not a deal. This is a really, really sneaky one, because this is the best example of one where the agents in question, all of them didn't do, both of the agents involved didn't do anything, any of the usual big stuff wrong, not usual for either of the agents, didn't do any of the most common stuff that we're used to thinking of that can cause problems. So, 2 offers are written on a 2-unit building. Both offers were written by different agents. One was a listing agent, one was an outside agent. Both offers are written on an MLS residential sales contract. Seller accepts one of the offers, resulting in a fully executed contract. Okay, multiple offers come in, seller duly analyzes both offers, picks the better one at that time, makes a decision, executes a contract. There was, at that point, a valid executed contract. Sellers then, essentially after the buzzer, so you think of the contract's fully executed, end of the game, buzzer is already sounded. The sellers after that think, you know what, this other agent is now suggesting that there would have been a better offer yet, and wants to present a better offer. But I'm already under contract. So not only am I thinking, how could I weasel out of my contract, but I'm also unhappy because I feel like I'm in a contract I shouldn't have been in. No fault of the agents at all. So the losing buyer wants to make another attempt, basically after the buzzer. You got the sellers who are thinking, I now want to bail because now I think there's a better deal to be had. And the liability part of this is, if the sellers and the losing buyers find a way to bail so that the sellers get out of their contract with the winning buyers, the original winning buyers would potentially sue, because it gets bid up after the whole point is you bring your highest and best. If that's the protocol that was used, bring your highest and best. Everyone said this is our highest and best. Sellers pick, and then one of the parties says afterward, well, it wasn't really, I'm going to do better. Well, you now have the buyers whose offer was initially accepted, if the sellers were to bail, saying, hey, wait a minute, I was promised that I was executing a binding contract for this price, and now you're telling me the only way to get the property, if the sellers find a way to bail out of it, is to pay a higher price. That's where the liability comes into play. So going back to, if you can find a way to crack open the contract against the wishes of the seller in this case, if you find a way to crack open the contract and it turns out the only way for the seller to be able to, for that first buyer to be able to stay under contract is to pay a higher price than what their first contract was at, if that's a difference of $5,000, you got a buyer thinking somebody owes me $5,000. So here's what happened. Wrong form was used. Let me show you. This is one of these things that's hidden in writing, in bold-faced type, on our residential sales contract that 95% of our realtors never read. So I'm obviously joking tongue-in-cheek about it being hidden because it's really dressed up to be very, very visible, but the realtors never see it, and I get that. So that's why I'm talking about it, because it is an easy mistake to make, notwithstanding the fact that it is bolded. But the underlining is mine. The bolding and the all caps is exactly how it appears on the contract. So remember I said earlier that that contract, when executed, was valid? There isn't a question that you have a valid contract. So if you misuse the residential sales contract and the parties all sign off on it and they use that to go all the way to closing, totally fine. We have a perfectly usable contract that's in our file. Here is the problem. It's the voidable word. Voidable by either party. So yes, you have a valid contract. The contract is not void on its face. It's not invalid because the wrong form is used. It is merely voidable at the option of either party. In other words, it just means, yes, it's valid, it's legal to use, it just doesn't really hold anyone into the deal, because as soon as somebody wants to bail, either buyer or seller terminate like that. Voidable at the option of either party. So you then combine that with this fact pattern where easy mistake to make, and in most cases, you make the mistake with the wrong form and everyone gets to closing and it really isn't a problem. I mean, honestly, at least 9 times out of 10, everyone would treat it as a binding contract that they were stuck with and they get to closing. This happened to be this really unusual case where there was the wrong form used, which usually wouldn't cause a problem, and there were the multiple offers, and the sellers wanted to find a way out after they'd executed. And so the conversation was, as soon as those sellers consult with their attorney is going to say, you guys can bail out like that and go take a better offer, the offer that came in after the buzzer, with the second buyers, leaving the first buyers out in the cold, and the first buyers are going to want to sue you. Everyone got it? Everyone see how crazy easy we could end up in that situation? So we have an in-person house hunt. I say in-person because you think fraudulent buyer, you think it's a sheik overseas who has money that is in exile and has money they need to invest in the United States, and you never actually see them. I had one of those offers from another agent last year. This was real people who were in one of our agent's cars doing a real in-person house hunt. They made an offer. The offer was a cash offer. It said, handwritten into the contract, subject to verification of funds and by a certain date. All right, that's problem number one. We'll come back to that in a minute. It also then was followed up, so everyone signs it. Everyone signs it. It had a short-term period, 4 or 5 days, to get the verification of funds. So the offer gets signed by the seller. They come to terms. It's subject to the verification of funds and I think maybe an inspection contingency. The verification of funds did not come in any of the usual forms. All that was proffered as a verification of funds was a screen capture purporting to show an account balance supposedly representing funds in the possession of the buyers. And so both agents are like, this totally does not smell right. And so that was the first sign of trouble. I think the listing remained active at this period of time while they were waiting for the funds verification, and the earnest money check was held pending verification of funds, held by the buyer's agent. I know. Here we go. Here we go. So we got issues. We got earnest money not deposited. We got a proof of funds contingency issue. So issue number one is when that contract is signed, no matter what contingencies are in it, once it is signed by everybody, it is a fully executed contract. That is no different than a contract that has an inspection contingency or that has a financing contingency. We do not wait to deposit the earnest money in those cases. We deposit it, just like we're required to under the law, within 1 business day. You get certain types of contingencies that make us feel like it's not a done deal contract. In this case, it was, I won't feel like it's a done deal until I see if these people are good for the money. Or the most common scenario is, this isn't a done deal until we get third-party approval on this short sale. That's the other type of scenario where it's very easy to feel like it's not a done deal, not a real contract. And so we have seen several times where people would mistakenly think, we don't have to deposit the earnest money until we get the third-party approval. But it is a fully executed contract, just subject to contingencies. So the earnest money needed to be deposited. That was an issue on 2 levels. Number one, we want to make sure we're compliant. But number 2, you could have a fraudulent buyer whose earnest money check does clear the bank. So if their earnest money were to clear, it doesn't guarantee that they're not still fraudulent. But by golly, if it doesn't clear, we know real early that there's trouble. And so as soon as the fact pattern was made apparent to me, we got the earnest money deposited. Sure enough, it bounced. It was, I don't remember if it was written on a closed account or if it was just an NSF check, but it bounced. And it took a few days to confirm that because from a banking standpoint, as best we can determine, it was somebody who was going to attempt to maybe get an earnest money refund issued back before the NSF had come to our attention, as far as we can tell. But it wasn't a big enough sum of money that it would have been worth identifying yourself to the agent, getting in the backseat of their car, doing a house hunt. So I mean, we still don't know exactly what was going on in their heads. But it took a while. I mean, Julie had to call the bank. What happens when it bounces the first time is it gets sent back through. So there's a period of multiple business days. So we already had a delay before it was attempted to be deposited, followed by a further delay because it comes through NSF the first time, gets put back through a second time, and only then, when Julie had called and spoke with the depositing institution directly, did they confirm that no, it had not gone. So that took a while. And the other issue on that offer is we have an MLS form for cash purchase with contingency. Use that. But better yet, don't use it. What's one of the biggest advantages of having a cash buyer? Right, no contingencies. It's a sure thing. So I encourage you, you are going to undercut a huge part of the advantage of having a cash buyer if you erode that certainty that normally goes with a cash buyer. I mean, what I tell typical buyers who are getting conventional financing all the time, you need to work with a reputable local lender with excellent credibility, because if you work with somebody whose credibility is perfect, to the seller and to the seller's agent, it's going to feel like you're backing a Brinks truck full of cash into their driveway, because it's going to feel that certain. Yes, they're getting financing. It's a lender that if they've issued a pre-approval, they are delivering the money at closing, and so it is as sure a thing as backing a Brinks truck of cash into the driveway. Well, the only thing better than that is actually having a big pile of cash to back into the driveway. Why would you undercut yourself by saying, I'm going to suggest to you, Mr. Seller, that we have a big Brinks truck full of cash that we could back into your driveway. We don't have any proof that we have that money today. Give us a little while, and trust me, we'll produce the proof later. There are certain reasons why you may want to do that. For example, if you're waiting to get a statement or a letter from a bank officer or a brokerage account manager or something like that, and you know your client and vouch for him to the other agent, you want to get the offer in, but you still need to give the 3, 4, 5, 7 days. But whenever possible, have all the proof of funds that you would reasonably be expected or wanted to have by the other agent and by the other party. up front. Otherwise, you're undercutting the primary benefit of somebody who's walking around ready to pay cash. So, if you're going to use the subject to availability of funds contingency, use the MLS contingency, because that already provides and makes it pretty obvious how you terminate the contract if that's not provided. Whereas if you handwrite stuff in, that is almost always going to be the problem. It lacks detail. How do you exercise that contingency? What do you do? What are your deadlines, et cetera, et cetera? So the handwriting in is a bad idea, especially when we have a MLS form for that purpose. So those are the two buyer side issues, earnest money and the handwritten contingency. Seller side issues. All right. So then the check bounces. It's got bogus buyer written all over it. The buyer's agent actually reaches the buyers, and the buyers, without being at all specific, basically said, "We are so sorry, it turns out we're not going to have the money available." They didn't crawl under a rock, they actually responded. So at any rate, the buyer's agent knew affirmatively, all right, now I've heard directly from them, there's no way they're buying this thing. All right, but we have this fully executed contract hanging out there. At this point, the buyers are, after coming up long enough to tell their agent that they aren't buying it, they do go crawl under a rock. So we're not going to find them again. We got a fully executed contract. We got a listing agent who's trying to decide, what do I do with this thing? The listing agent puts it back on the market. It goes back and the MLS is active. Can't do it. Again, it feels perfectly okay to do it because you know that is a dead deal. There is no way that that's going to pull a Lazarus and be resurrected and be ready to go again. There is no possible way. But the reality is that property remained encumbered by a fully executed sales contract. And under our MLS rules, and just more broadly our legal and ethical obligation to paint a true and accurate picture in our marketing, you can't put that out there as available as an active listing with no caveats to it when it is encumbered by a fully executed sales contract. Albeit one that we think is dead in the water, but it's still fully executed at that time. So the post-mortem on this was, all right, so now we can't do the easy thing, which is have the parties sign off on a release, because half of the parties have crawled under a rock. And they don't have any skin in the game. They bounce an earnest money check on it. It's not like they're going to crawl out from under their rocks. They can get their earnest money refunded because they bounced their earnest money check in the first place. So the next step was, listen, that listing has to either stay pending or go to K status. If you use K status, what do we think? If we're on the buyer side and we're perusing listings to show and you see one that's K, do you show it? No. We assume that it's a short sale that's already got an accepted offer waiting for third-party approval. That is the most common use of that K. Or it's some seller who says, I want it to be able to be shown, but it's already sold. We're waiting for a home inspection. Well, K status, if you're going to put it in K, I had told that agent, make sure you put in the agent remarks, subject only to final termination of a previous contract that's already dead, or something like that. You don't want to just put call listing agent, and you don't want to put no detail, because we all know from experience that we're not going to put on our list. We're not going to waste our time showing buyers properties that are already sold or already have somebody in line first. But we can't put that back at active at that point. So that was another wrinkle, another complication. That agent, I advised that she get in touch with her client's attorney, get that attorney's take on it. The attorney then prepared a letter which we used for our file so that we had a reasonable legal opinion on file stating, for these reasons, and the attorney recited a list of reasons, this contract is now considered terminated and is now void, and the property is now able to be put back on the market. So we had to go through some extra steps just to essentially clear that so the property could go back on. But until all of that was done, you really can't have it on as active status. Susan?
Being that it was a cash closing, was there a quick closing date, and once that date is passed, does that automatically make that dead?
No, I don't remember, and no. I don't remember if it was a fast closing, and if the date came and went, it doesn't make it dead. It just means you got a buyer in default. So that's why we had to get into a lawyer's formal legal opinion as to, can we call it dead at this point? And have we taken all the steps that we need to, given that we know we're not going to get an affirmative response from this other party? But you could just as easily argue, if it was cash and had no contingencies, hey, you got past your closing date, you haven't closed, you have no contingencies, that doesn't mean we have no contract, that means we're going to sue you. The other similar issue where it was Bill Mitchell, and he gave me permission years ago to use this example because it's it's a really good example of somebody who was doing right by his client and would have never in a million years thought that a dead deal was going to pull a Lazarus and then pop back up from the dead. Bill Mitchell, several years ago, in fact, when I told him, recited the story back to him, he had forgotten that he had told me about it. So many years ago, Mitch had a deal that went south. Buyers couldn't get their financing. They had been to like 4,000 different banks, and it was apparent there was no possible way they were getting financed. They didn't have a final release signed, so the contract had not been formally terminated, but he knew it was dead, no question. Property goes back to active status, which he did ASAP once he knew with certainty that first deal was dead, but not formally released, because he wanted to mitigate the damages to his seller. He's doing right by his seller to try to make sure that it can get back on the market, get sold ASAP, not lose any marketing time. Hallelujah, another buyer comes along like that. Oops. Second buyer comes along, fully executed contract. First buyer, I think it was Bank of Grandma or something like that, but first buyer turns up with money. Hey, good news, we can close on the property. So now you have a seller who has formally promised to sell the same house to two different sets of buyers. And so at that point, and this is several years ago, so this is long before I was an owner, but at that point there was, I believe, an E&O claim and a settlement paid out because we were responsible for having damaged one of those parties. And I use that as an example and had asked Mitch for permission to do so because we can all imagine, oh, well, I would have done the same thing because I'm doing it to protect the interests of the seller, my client, and I only did that after it was apparent that the first deal was completely dead. But if it's still out there, there's always a chance it pops back up. Any questions on that subject? Edna?
So officially, we should not put them back in active status until we have the signed release form, or...
Right. And if you did, now you would still technically be in violation of the MLS rules, which I of course cannot condone, but if you were to do that anyway, I would at a minimum put in the agent remarks, because what you don't want to have happen is have somebody get ticked off because you suddenly run into an unexpected wrinkle and you didn't say a word anywhere in that listing about, by the way, there's the little fine print of, there is this other deal we're waiting to terminate. But as you know, if you're 99% sure that that it will terminate, or that there are cases where you may have a seller whose attorney says, no, we're not letting them out of the deal, we're not sure if we're going to sue them or not yet. You put it back on the market to test the waters. We're not going to sue them if we can resell the property and mitigate our damages, but we want to keep them under contract and keep our right to sue them. If we do a mutual release and agree, you're out and we're not suing you, well then you can't sue them. So every once in a while you may have an attorney who says, we don't want to let them out, but we want to test the waters and see if we can get it resold, because if we can't get it resold, that may make us want to take legal action against that buyer. So there are all sorts of situations where you may, for very specific reasons, not formally terminate it, but be under the distinct impression if a termination were offered with no penalties, that buyer would be on it like that. But until it's fully executed, you never know, and so you always have to make sure somewhere in that listing you've got, doesn't have to necessarily be public facing, but at least in the agent remarks, FYI, there is this previous contract and any offer will be contingent upon termination of that, call for details. And then you explain, but say, please show previous offer awaiting termination, that sort of thing.
I have a question.
Yeah, Phyllis.
I've had this 2 deals just recent where there's an executor, the owner has passed away and the executor's taken over. Okay, one I wrote an offer on and the listing agent didn't have any disclosures because he was dealing with an executor. When I'm dealing with an executor, I still have disclosures. What's the right way?
As far as I know, the only disclosure that is exempted in that case is the Illinois Residential Real Property Disclosure. Right. And this is, again, one of those things that's hidden in writing on the form. But if you look on page 2 of that form, the statute, you'll see the list of exemptions. And it'll say if it's incident to a corporate relocation, or if it's incident to a transfer between spouses, or if it's an executor administering a decedent's estate, it'll have a whole laundry list of circumstances under which it is exempt from the disclosure. In many cases, the executor does know something about the property or about that decedent, and so it never hurts to have them fill it out if they're willing. Be aware they don't have to, and their lawyer could advise them as such, or you could, for whatever reason, decide you're not going to. As far as I know, there is no such exemption for lead or radon. I'd have to double check. If there were going to be one, it would be more likely to be radon because that's a state statute, and it would stand to reason that may be subject to the same set of exemptions. But I know for sure that the Illinois Residential Real Property Disclosure Act has various exemptions, including the scenario you described. I'm not aware that the lead disclosure, which is a federally mandated disclosure, or our separate radon disclosure, which is state mandated, have those same exclusions.
That's why I have to do the lead and the radon, but not the...
Sure, which is totally fine.
But from this other agent, we got no disclosures.
That'd be a reason to bring that to the attention of your client's attorney early on, so your client's attorney can advise whether that's key. It's very high liability if you're the listing agent and you fail to comply. It's very high liability because there are potential penalties or a statutory right for the buyer to bail. It's kind of like that, use the wrong form and it's voidable at the option of either party. Failure to comply with the Illinois Residential Real Property Disclosure Act leaves the contract voidable at the option of the buyer.
Well, when I talked to that realtor who is not in this office, I said, where are the disclosures? He said, oh, we don't need those. It's an executive.
Right. Yeah. But I will tell you, at that point, you don't want to get into a spitting match. You're going to probably, it's a small town. You're going to see that agent again someday. This is another reason why having an attorney is a great thing, because the attorney can be the designated bad guy. Then you're not the evil witch that won't take no for an answer and is pestering the other agent. Then you have the attorney who calls and says, hey, we got a problem. Okay, and the last item I had on the list before we hit the top of the hour, which also was on this list of things that came up within this short period of time, relo and institutional contract issues. So when you're dealing with either an REO, so a HUD or a Fannie or a Freddie foreclosure sale or a relocation facilitated sale, what is one of the things that you see almost all the time when you actually are going to do the offer and get a contract? Yes. You'll have one of two things. You'll either have a proprietary contract that they make you use, or I think more commonly now, with relo companies anyway, you will see a proprietary rider or addendum to the contract that is mandatory. From our standpoint, the rider or addendum feels more comfortable because we're still using a familiar form that has that attached to it. But that is, don't get lulled into a false sense of security, because the problem there is, why is it that those relo companies or institutional sellers use those riders? What's their rationale? There's a perfectly good reason for it.
They want to be totally control of the transaction.
Yes. Yeah, and it's not just control. So Fred's answer was they want to be totally control of the transaction. It's not all control, but it's partly,
Reliability.
that is another part of it, but it's also, they can't have,
It's standardization, so they know.
They
know what's in there.
Fred's and Susan's points were valid. Probably the overarching issue is they need to know that they don't have to have their legal department review every separate little MLS's contract for every separate deal across all 50 states. They need to know, no matter what jurisdiction, no matter what state, no matter what MLS we're dealing with, that we have certain uniform terms that we know are a part of all of our deals, and so all of those things go into the rider. Now, what is a absolutely 100% of the time ubiquitous provision in those riders?
Home inspection within 5 to 10 days.
That is almost always the case,
But
and
it basically states that the first contract, the one you wrote, is void.
that's not what it says, but that's the effect. So Fred said it states the first contract is void. Well, what it says is if this rider conflicts with any provisions in the contract to which it's attached, that to the extent that the documents disagree with one another, the rider will supersede the contract to which it is attached. Well, it turns out that those riders cover a whole lot of stuff that's also covered in our contract, so it turns out there's conflicts left and right on things like title closing costs, inspection time frame, termite provisions, all sorts of things that we take for granted because we know the ins and outs of our local residential sales contract, and suddenly you're dealing with one of these institutional contracts and all of that stuff is out the window. And yes, you filled out an MLS contract and you felt secure and cozy knowing that you were working within the friendly confines of the document that I have personally toiled over for the last 12 years. But don't feel that way because you've got this foreign document that we are not trained on. So the very, very most important thing when you're dealing with a reload deal or a corporate REO type of deal, very most important thing is get your buyer an attorney early. It is, I would suggest to you it is okay, since we're dealing with forms that we're trained on, if you were to say to your client, here's our residential sales contract, I'll walk you through how it works. I won't give you a legal explanation, but I won't give you legal advice, but I'll walk you through how it works. If you have legal questions, you need to talk to an attorney. If you do not, this is a standard form that I am authorized to be able to walk you through and fill out. We can't say that about a reload contract writer. We can't say that about the REO proprietary sales contract that they're using. And not only can't we say it because we're unfamiliar and not trained on them, but as has already been pointed out, I think by Fred, they want complete control, they want to avoid liability, and so they are going to be way less buyer friendly. Way less buyer friendly. So it's different, it's foreign, it conflicts with our contract, we're not trained on it, and it's going to be much, much less protective of buyers than our standard MLS contract. So all of that means the upshot is get those buyers in communication with an attorney whenever possible before they tender the offer. And also, on the subject of setting expectations, on those types of reload deals, what's the single most common sticker shock related problem that hits our buyers? Let me focus that question a little bit. Title insurance related costs in Champaign, Illinois and the surrounding area are the envy of the rest of the country. What is one of the most common problems that pops up in reload deals if you're on the buyer side?
They pick up additional expense.
Yeah. So whereas the buyer in a typical transaction here might be on the hook for $150 of title charges, it comes through the relocation company's incestuously related title company out of area. We get worse service, and oh, by the way, your buyer is on the hook for $750 of title charges. That is not an exaggeration. It is very commonly a multiple of what the buyer would have paid in our local market. So there's a couple of things here. Get them to the attorney sooner rather than later, because we can't give them any legal advice ever, but we're not trained on their contracts. So it's not our job to know the ins and outs of every different relocation company contract. Secondly, set expectations appropriately. Mr. and Mrs. Buyer, let me tell you how the relocation process works. It's being facilitated by a relocation company. They're going to be cold calculating. They don't want to take this property into inventory. That may mean you could score a slightly better deal than you could have with some other property where there weren't relocation benefits involved. Let me tell you though, it's possible you may pay, there's some bureaucratic stuff that we have to jump through. It's possible you may end up with slightly higher closing costs because we're not going to have control over the title company used. Let them know that up front. If they're getting a $5,000 better deal on the house, does it matter if they're paying an extra $400 or $500 on buyer title charges? No, they're still getting a $4,000 or $4,500 net better deal than they otherwise would have gotten. It's all about the expectations. They'll forget all about the good deal if they're not expecting to get hit with the extra $500 in title charges, and you didn't mention it, and their attorney says, what kind of an idiot got you into a contract where you're paying 5 times the local customary title charges? Well, that idiot. His name is Matt. So again, if you set the expectations, and if they decline to have an attorney and you at least raise that red flag a little bit, but set it against the backdrop of, but there's also probably potential for a slightly better deal, and we have sellers who usually are not having to pay their own brokerage fees, and so they may be a little more willing to cut a deal, it's all good. But the reason this issue came up is I had one of our agents that contacted me and said, all right, I got people who had a home inspection, it's a reload deal, and they need to get out of the contract. Do I just serve that unilateral termination of contract notice post-inspection form?
Probably not.
Absolutely not. Because that form only works with the CCAR MLS residential sales contract inspection contingency. And even though that agent had filled in deadlines for the CCAR residential sales contract inspection contingency, They don't mean anything because there's a rider that's attached with its own inspection contingency, and that completely wipes out our inspection contingency, and we don't have a form for that. So the client who wanted to bail was able to bail, but we potentially would have jeopardized their ability to do so if we had used the wrong form or hadn't followed the protocols that are prescribed in the... So that was a get them with an attorney immediately. You don't want your fingerprints on anything with regard to someone else's proprietary contract inspection contingency. Get them in the hands of the attorney. Have the attorney take it from here, because in this case, the last thing we want to have happen, when they wanted out, they didn't just want repairs or else they would bail. They wanted out. It was one of those deals where now that we know what we know about the property, it doesn't matter what they do, what they spend, we don't want it. So if you get anything other than terminated contract earnest money refunded, you're going to have a buyer wanting to sue you about it. And so the stakes were very, very high. And it's a terrible situation to be in, because it's a situation where we're not getting paid and we have to work our tails off and be extra careful, and we're in a minefield, so we're not getting paid if it goes the way they want it to, and if they get sued over it, we're not getting paid and we're getting sued. And I'm going to quote Brad Quotes, one of my favorite Brad Quotes quotes, although there are several, but one of my favorites is, you know, Mr. and Mrs. Seller, I'm paid to get people under contract and get them successfully to closing. My job isn't to bail you out of contracts. So while I understand what we need to do, you're really going to have to deal with an attorney on this particular issue, because it's not really in my job description to demolish contracts. But it's a really friendly kind of folksy way of saying you need an attorney, because now you're kind of getting outside of what my job description includes. Curtis.
Have you had any experience, or could you give me any advice on dealing with short sale pros?
Only...
Can we quote you, man?
No, yeah. What, before we let everyone go, the only thing I would say about short sale pros is we are likely going to move into, with new lending regulations, Tom Roth spoke to this issue a few weeks ago. The problem with the short sale pros model is under the new lending regulations, it will likely be considered an impermissible closing cost that goes beyond what the buyer's permitted to pay if they're getting financing, because the new lender regulations have that the closing cost can only be up to a certain percentage of the total deal. Well, so our customary closing costs in our local market are well within that percentage. But you tack on the out-of-pocket buyer fee that short sale pros charges, and you're busting into that, past that limit threshold, at which point it could be deemed illegal. So that's going to be the big problem going forward. I'm happy to discuss specifics with you individually, but the short sale pros, and that was honestly that's part of why we had Tina Manuel in here, because we wanted to make sure everyone was aware. We got another attorney who does a fair bit of short sale work, actually likes it. I'm not sure what that says about Tina, but I mean, just diligent. She's used the term, it's mind candy. It's one of those things where it gives her, it's a challenge. Yeah, right. No two are quite alike. So anyway, I'll discuss that with you in more detail if you have specific questions, but generally that's the big headline issue we all need to be aware of, is double check with, if you have a buyer contemplating a short sale purchase and it's being facilitated by a short sale company that has a buyer fee that's due, run it by the lender, and specifically, because this is new to the lenders, the originators may not all be up to speed on it depending on what lender you're using. Run it past the lender and say, specifically, our question is, will this cause problems in terms of new lending regulations exceeding the allowable percentage of the deal that's attributable to closing costs? And I'll hang around if you guys have other questions, but that's what I got for today. Thank you all.